Welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted, website, of course, markstevens.net. Glad to be with you here live from the fortified compound in Mesa, Arizona, where it is March 7, 2018. This is the 54th, the 54th episode of the live edition of the No State Project here on my YouTube channel, where we are commercial free every Wednesday from 4 to 5 Mountain Standard Time. How do you edit times on the website? Yeah, I'm not going to work it out right here. Too much going on, entirely too much going on, dealing with far too many bureaucrats. We've got a proven record over a decade long. Some of it's posted on the website. I didn't always post that stuff. Of course, I didn't want to get pigeonholed as the traffic ticket and tax guy, but you see, you can all see how well that worked out. So, anyway, what we do here is we talk about anarchy getting to a voluntary society, and when we're being attacked by a bureaucrat, we take an anarchist perspective when we go into court, because because you want to start off, you want to have a rational defense. You want to be using logic. You want to be using reason. And so some might have you go in under the impression that the laws do apply and that the government is just been corrupted, that over the years that what started out as pure just got corrupted, because power corrupts, and absolute power, of course, we've heard that quote for over 100 years. And it's true, power does corrupt. I don't believe in doing that. I don't believe in giving the prosecution a free pass. Why should you do that? I don't see where that's logical. It comes down to, you're going to help the prosecutor, you're going to help the police officer, or even a judge, you're going to help them prosecute you? Why should you go in under the presumption, or giving them a presumption of correctness, that their claims are true? Now, I'd be the first to admit it is unorthodox. We are challenging a sacred cow. I don't know why some people... I guess maybe I do. I guess we just been conditioned to believe in this stuff, and it's very difficult to go in. So I guess there's at least two different schools of thought there. You got the people who are just so conditioned they can't possibly question something like that. And that's why you have people who threaten you, me very few, where they'll say, get within arm's length of me, arm's distance of me. Then ask me for evidence proving the laws and the Constitution applies, and I will give you your answer without saying a word. So punching me, or this is the thing, trying to get a punch landed, that is going to prove that your Constitution applies? That's going to prove the laws apply? Yeah. But that's the level of discourse you're going to have on places like Facebook, which is why I say I'm a phone. I will not post on Facebook. Not worth it. I have given it an honest effort. I have tried. I have tried to have an honest, just open discourse and discussion of issues on an anarchist site, or Facebook, for anarchism or voluntarism. It's not possible. There's always seems to be some kind of trigger that someone's going to get pissed off, and they just have to resort to ad hominems. Well, Mark, your position is well laid out, it's logical, it's logically and ethically consistent, but because you're an idiot, I'm going to reject the entire thing. I'm just going to go based on what I was told. So again, especially if you're new, and I do appreciate the new callers and new subs, the foundation of our defense, regardless of who's launching the attack, and whatever the code violation tends to be, that's not relevant. Remember, I'll say it every single show. Relevance is king when you are going into court. If it's not relevant, it doesn't matter how correct it is. It doesn't matter how brutally just devastating it is to your opponent's argument. If you haven't established relevance, it doesn't matter. That's the way, like the back of Adventures in Legal Land, the three monkeys. They don't hear it, they don't see it, they're not going to say it. Relevance. You have to show the relevance. And that's why we are going to attack the very foundation of the prosecution's case. So people are like, but that's so that just seems so extreme. Really? What's extreme? Making the challenge and trying to hold the prosecution to their burden of proof. Just making the challenge. Just, hey, do you have evidence to support your claim? Or is what's really, extreme and detrimental to our goal of damage control, giving the prosecution a free pass. None of this, so here I on Facebook, hey, tough guy, get within arm's reach of me and I'll show you that the law applies. That's what you get on Facebook. You get the same kind of garbage, just a little bit more sophisticated, when you talk to a Supreme Court Chief Justice like I did. Him and Bill Montgomery with the county attorney here in Phoenix. The evidence proving the law, our laws apply to you, is the other people that we put in prison. Got it? The fact that you're willing to attack me is not evidence. Do we really... Is this something that really needs to be said? Why would anyone take seriously somebody saying that I will get within arm's reach of me and I will give you the evidence the laws apply? This is the level of discourse. Not everybody on Facebook, of course not. I'm sure there's very good people like I would want it to do that want to have an actual honest discussion. You can't do it on Facebook. Just like you can't do it on most YouTube videos. Yeah, we get pretty good here on a live broadcast. Sure. But look at some of these... Oh man, are we getting locked up again? But look at some of the videos and the comments that you get. And what it always comes down to, it seems, is ignoring the fundamental principles of logic. The burden of proof is on the one making the accusation. And if you want to get somewhere with these people, you have to keep the burden of proof on them. So to get back, again, for new people, and I appreciate you tuning in, we are using three basic principles to hold them to their burden of proof and to defend ourselves. Three general principles, okay? Well, one's less general. One, you're going to challenge the claims be made against you. You cannot give the prosecution, you cannot give your accuser a free pass. I don't care if it seems obvious to you. Challenge them anyway and make them do their job. You'd be really surprised at what happens when you challenge these sacred cows. No free passes, and then you have to hit them where they breathe. You got to go for the jugular there. You have to challenge the foundation of their claim. And that is the opinion, if they're physically here in Arizona, the laws apply to you. Yeah. Again, they'll either argue that they'll punch you in the face as proof of their claim, or they'll make the claim, we don't have to prove that. We are special. It is not only morally right when we steal from you and kidnap you and falsely imprison you. We have that moral right. We also have the right to make claims against you without any evidence. How good is my De Niro impression? A little bit. It's a little bit. It's all right. All right. Let's go to the phones here, because that's what we're here to do, is to help people effectively defend themselves. So we've got a new caller here. Looks like it's Washington. We have area code 541. You're live on the No State Project. What's your name? Where are you calling from?
Hey, Mark. My name is Beth. We talked through email.
Oh, well, welcome. And you are calling from Washington, Beth?
Yeah.
All right. Well, what do you got for us today?
Nothing. I was not able to call in last week to talk about my win, so I figured I'd call in today.
Oh, fantastic. Well, tell us about it. Tell us what happened.
So about a year before this all happened, I had a boyfriend, and there was an incident, and a no-contact order was put in place. Fast forward a year and a half. We are traveling through Washington. I'm heading home. I've got my kids and animals in the car, and it's about midnight. Got pulled over for a headlight out. And he asked me, since I was driving, for my information, and I told him no, I was not going to provide him with that. And he ran the car plates, and they happened to be in my ex-boyfriend's name. And as soon as that came up, it also came up that there was a no-contact order between him and I, so he instantly knew who I was. And I knew that I was driving while suspended, but wasn't going to give him any information, and proceeded to ask him about my right to travel and his codes and laws and statutes and how they don't apply. And long story short, he ended up he arrested my ex-boyfriend, and he made me have my car towed into the town, told me I couldn't drive, cost me $400, had to get a motel room for the night. The cops sat there and just watched all night long to make sure I wasn't going to drive. They issued a warrant for my arrest because I never went to court for it. And I was dealing with something in November, so fast forward about 9 months, and decided I wanted to get that warrant taken care of. So I went to the court, and they do a thing where you can get rid of your warrants that day. So anyways, they booked and released me and made me fill out this piece of paper saying that for public representation. And I said, no, thank you. I will represent myself. And the judge did not like that. She wanted to know why. So I told her I didn't want to waste the state's resources. Anyways, so it's fast forward another 2 months. Say what?
So that's big of you.
Right? Isn't that nice? So anyways, fast forward another 2 months. We're getting ready to it's going to trial because I said not guilty. And so they had set a trial date out it was actually February something. And 2 days before the court date, I had mailed my all my paperwork, your paperwork. And so they sent it, they received it, they sent me back my copies. And the very next day in the mail, I got a letter saying that it was dismissed. The reason that they dismissed it was absolutely ludicrous. I've never heard of it before.
Yeah.
But it was very apparent she didn't want to play.
Well, yeah, it was. I saw that, and I'm like, I see what she's talking about here. This is a little odd. What the hell did the one have to do with the other? And they usually, they still took your car. They charged you all this money. They issued a warrant for your arrest because they thought it was so serious that you get in there that they were willing to use deadly force to get you into the courtroom. And the day after you filed a motion to dismiss, trying to, pointing out that the prosecution hasn't met their burden of proof, they kick it out. Well, that's not. Well, what happened did anything happen with the no contact charge against the ex?
So it was interesting because there was not supposed to be a no contact order. What happened? He had been arrested for a domestic disturbance, and he was booked and released. Part of the conditional release agreement was that there was no contact with me, the victim. So once he takes a plea and sentence, once he takes the plea or is sentenced and convicted, that no contact order is supposed to go away. It can only last for 1 year. During that whole year, we were trying to fight it, and he went to jail a couple of times, but it should have been dropped after 1 year. So when I was at the courthouse dealing with that warrant for me, and the lady was talking to me, she goes, well, so it was a no contact order. I said, yeah, and it shouldn't have been there. So she starts looking me up. She goes, it's not in any of our files. It's not there. And she goes, it only would have lasted for up to one year. So it should have never even been in the computers.
What I would do here, and I want to get to this right to travel stuff that just set off the alarms, but I would file. I can't let that go. I would file a claim against the county or the city, whoever did this and was responsible for doing that. I would file against the risk management to get that $400+ back, because you also had to pay for a hotel room, and that had to be at least $100. Yeah, at least $100.
It was ridiculous. Not to mention, when they towed me into this town, it's a really small town, so everything is closed down. And the guy said, no, we'll have you towed to a motel. And I said, are they going to be open even? And he said, yes. So I get dropped off in the middle of this little town, and everything is closed. The motel doesn't open. I was sitting there. I even called the state police back, and I was like, listen, I can see another motel about a mile away. Can I drive to it? But my kids and my animals and myself are in the car, and the cops are sitting right here watching. She said, oh, no, you cannot. Do not drive. So I had to have the car towed to the next motel, even after he promised me that there was one. I had to pay $150 for the motel. It was retarded.
Yeah, there's no doubt that this was, it could have been a lot worse, but still, I would file, you probably have a claim against the insurance for $700-800 when all told. Right. And I would get, and it helps that they dismissed the charge against you. Yes,
absolutely. But they said that it was in the context of a domestic violence, and it wasn't. It was in the context of a headlight being out.
Yeah, and they did. But the big charge was the driver's license. If it was just a headlight, they would have given you a ticket for that, and they would have let you go on your way. They took the car because of the suspended driver's license. That's where. So they threw that charge out, which is nice. And then now I would file a small claim against their insurance to get it back. Yeah, name the police officer, name the people that were involved, of course, and then you want your damn and have the receipt. Have copies of the receipts of the money that you had to spend, and also the fact that it puts you out. I mean, you had animals with you. You may not have been able to get them into a motel. Not every motel is animal.
Yeah, it was. Especially, I have a special kind of weird animal, so yeah, it was very hard. I had to pay an extra $100 deposit that I ended up getting back, but
still, I mean, this is in the middle of the night with your kids, so I have to address this stuff about the right to travel.
Let's hear it.
Yeah, you got to know from listening to the show, and we've debunked that stuff so many times, that even if there was legitimacy to the theoretical issues of law that form that argument, the fact is theoretical issues of law are a very ineffective way to argue in court. They don't give a damn. So for you and those listening who might want to go down that road, well, why shouldn't I? My interpretation of the law is absolutely correct. Well, for one, they don't care. They don't give a damn.
Right.
If you file your issues of law, your theoretical issues of law, you're going to find that they don't care. They're going to have conflicting opinions that their courts agree with them on. And if they've got conflicting opinions on the law, backed up by their courts, you don't stand a chance in hell of winning. So it's just...
Exactly, you'll lose.
Yeah, so it's a very ineffective way to defend yourself. The other thing, too...
So I was giving him help, and honestly, I hadn't even heard of you when this all happened, and it wasn't until after all that had happened that I got in contact with another one of your supporters, Jay Heretic, and he was the one that introduced me to you and all your versions. So when I was talking to the officer that night, I was asking him about my right to travel and how his statutes and codes don't apply. And of course, he was making any excuse he could, usurping everything I said. And it wasn't until after that I had discovered you and your method.
So now you know, and for everybody else out there, the side of the street is not the time to get into a discussion, because you have somebody with the emotional level of a 5-year-old, and I'm generalizing. Not all of them, most of them, and they're taught to be in control. So what do 5-year-olds do when they start losing control? They pitch a fit. So the guy's got a gun. Mm-hmm. The other thing is, well, there's two big issues here. One, you have no business talking to the cop. It's
Right.
you do the identification so you don't get shot, and then you keep your mouth shut. Two, when you are discussing things with these people, they're the accusers. The cop is the one making the allegations and going through the force continuum to get your compliance. He's the accuser. You probably know now already, and for new people, when we do talk with them, and we shouldn't be doing it on the side of the street, but when we do converse with them, when we are interacting with them, let them make their allegations, and then all you have to do is sit back and have them verify it. Well, why do you think that's true? Let me ask you a question. And then so you start going through and using questions, because what you're doing, from what you related, you were making statements that even if you were correct,
Right.
we already covered that they don't give a damn. I got a gun.
Right.
My boss says you're wrong. Come with me. And that's when they're being nice. Otherwise, they're just going to smash the window like what they did with Wonder Ann, and they're going to, they pull a 79-year-old woman out of the car, and then accuse them of resisting arrest. So we don't want to hear any more stories where the police are smashing windows on a traffic stop. So keep that in mind. The burden of proof should always stay on them. Oh, you think your laws apply to me? Do you have any actual proof for that? That's a lot more effective than saying your laws don't apply.
Well, so the interesting thing about all of this was when, during the time that I had the court appearance and I failed to appear and the warrant was issued for my arrest, I was dealing with some issues with my daughter. And there was actually a CPS worker and 2 officers that came out to my house. And there was no harm to the children, and CPS had no right to be there, but the officers were going to arrest me because of that warrant. And I said, no, absolutely not. Like, you're not arresting me. This is the wrong time to do this. Long story short, he ended up calling a supervisor and asking a supervisor, can we not arrest this lady? We don't want to take her in because of the circumstances. So they didn't. So I kind of had a moment to talk to them and pick their brains about some things too. And so I educated a couple of the police officers on, at my time, what I was thinking was my right to travel and whatnot. And ever since that was dropped and dismissed, like I said, I live in a small town. The officers were watching me every day. They're like, okay, you have time to take care of this court issue, but that's it. You can't be driving after that. They have since left me alone, completely left me alone. As soon as I got that dismissal, like something in their computer says, don't mess with her.
Well, it's nice to get that.
They see me every day.
I actually had someone at the DPS, the Department of Public Safety, the state police in Arizona, tell his unit, if you see in Mesa, or Gilbert actually at the time, the Gilbert Mesa area, and you see a Civic, a silver Honda Civic, without plates, just leave the guy alone. Just let it go.
Yep.
Just let it go. It's not worth it. So unfortunately, Mesa PD threw their hat in the ring a few months after that. So it's nice when you can get that. Well, I do appreciate you calling in, giving us some more details regarding that ticket getting thrown out. So for those who don't know, that was actually one of the latest success story that we posted at markstevens.net. It was with Beth, and the day after filing that the prosecution has not met their burden, they threw the whole thing out. And was it with prejudice? I'm trying to remember. I don't
Without prejudice.
Oh, it was without prejudice?
Mm-hmm.
Still, hey, it's still a dismissal. And I would go ahead and I would try to get my money back by filing a claim against their insurance. It was still thrown out, so it's worth a shot.
Thank you.
You're welcome. I appreciate the call. Beth in Washington, and one other thing we get straight is, we don't do the right to travel stuff. This whole thing about, and we've got Bao coming up here in a moment, so just hold on, and we'll just talk about court stuff, Bao. The right to travel stuff, so many of these court cases are taken out of context, and so one, for example, where the federal government said if the state tries to license a right by converting it into a privilege and taxing it, then you can ignore it. It's unconstitutional, and you can ignore the licensing scheme with impunity. And the problem is that you have to look at, you can't just cherry pick. So what a lot of the patriots in the 90s did, which is still continuing to this day, 20 years later, is they don't give you the whole ruling. And the ruling was, if the state government tries to tax as a privilege a federal right, then that doesn't wash. That they're not permitted to do that unless there's an agreement. And getting the driver's license doesn't implicate a federal right to travel. So that's another problem with using their court cases, which I know I do, but it's still not the most effective thing that, to defend against something. So some situations you have no choice, or you have to quote their rules to show how inconsistent and how unfair they are. But the right to travel stuff, nah, you're not gonna prevail on that. There's a long history of that. And yeah, you could get to a point where they don't want to be bothered with you. I can testify to that, just like Beth. Yeah, I knew that. The cop's name was Mike. He lived down the street. He actually lived in the same neighborhood as me, which was a little creepy, a little unsettling. So I know, I've been there, and I know it's not effective. So again, you get these situations where in a smaller area they tend to get to know you and they leave you alone. Hell, I got arrested on a bicycle, and there was 6 patrol cars that came out just because I had started to get quite a reputation in Mesa, and they wanted an opportunity to make fun of me and get some, because back then I was still and I hadn't learned my lesson to keep my mouth shut when talking to the cops. But anyway, that ticket wound up getting thrown out. Yeah, get a ticket on a bicycle. Ay vey. Yeah. All right, let's get to Bao. He's been on the show before. He is the subject of the tyranny spotlight with Cheryl Hardy. So welcome back to the show, Bao.
Hey, what's going on? Thank you for having me, Mark.
Hey, glad to have you back, my friend. So we can talk about court tomorrow. We don't have to talk about anything else. We can just talk about court.
Yeah, I'm going in tomorrow. I Googled the maximum penalty for Texas for a Class B misdemeanor is 180 days in jail and $2,000. So I don't think that's going to be an option for me. So the worst case scenario is just to be, and correct me if I'm wrong, Mark, plead not guilty, worst case scenario, and get out of there with my freedom, right?
If your back's up against the wall, hell yeah. I mean, if they're okay. We covered this on the show not too long ago. This is in front of Hardy again?
I don't know. I don't have a clue, Mark. I put in the 2 motions, one to recuse, one to disqualify. So I really don't know who's going to be honest.
Those are the same motions. Motion to recuse and disqualify are the same thing.
Gotcha.
So, and for those who don't know, we do that when we have evidence to show that the judge we have evidence proving that the judge cannot give us a fair trial, that the bias is so strong that a fair trial is not possible. But if you know in advance, there are rules in criminal procedure that allow you to recuse or disqualify a judge for no cause at all. Each party gets an opportunity to do that one time. So, but here we've got plenty of grounds to show that she is, this woman is not fit to be around other adults. So hopefully you don't have her. So if it comes down to it, so you can get the hell out of there, yeah. Well, you can just say under threat, duress, and coercion, and not guilty.
Gotcha. Yeah, that's what I was thinking. The best thing. I mean, we were just kind of brainstorming all kind of scenarios, and I just wanted to be just kind of a little bit more prepared for all the different scenarios that could happen.
Well, you make sure that the people that we had contact with last time contact us in case we have to do a habeas corpus for you again.
Got it. Yeah. I will. Yeah. There'll be plenty of people on the ground, or not plenty. There will be a couple of people that you can get in contact with in case I don't check back in.
Good, and definitely let us know. Don't keep us hanging. Just send a message. Guys, I'm okay. It's just don't leave it. Some people leave me hanging in a big way, and it kind of sucks because anyway. But are you going to go in and try, at least initially, to argue the motion to dismiss or the motion to disqualify if you have to? And if they're not going to get into that, are you going to let them know that you intend on pleading guilty and hit the prosecution's burden of proof again?
Yes. And that was one of the things I wanted to talk to you about was, so kind of like in that order, right? The first thing is going to be address the motions that have not been responded to up to this point. And then, if they completely ignore that, just, move forward with my intention to plead guilty.
Yeah, you got to push the issue of the prosecution's burden of proof. So,
Yep.
To not do that, to just give them a free pass, I can't get behind that. The only way, it's at least not this early in the game where you still have options to potentially some remedies to be able to get it out of there. So if the judge, for example, if the judge denies the motion to disqualify and recuse, at least you have the option of getting it reviewed. Now, it doesn't mean they're going the higher court. It doesn't mean if you file a petition for a writ to review the denial of a motion to change judge, it doesn't mean they're going to take jurisdiction. So like I've said before, we've got a pretty good track record of them taking jurisdiction in the state court. There's a zero success of them doing that at the federal level. The feds have never taken jurisdiction over a writ, not even a habeas corpus that that we filed. So keep that in mind. So at this stage of the game, you have still options available, so you don't have to throw a towel in and try to get it cleaned up on post-conviction relief or on appeal.
Right.
And we'll point out that no one has ever hinted at or tried to. I've never tried to use deception and not let people know that appeals or even doing a petition for a writ can be expensive. And an appeal it's a lot of work. And yes, you can be sanctioned hardcore on appeals. Of course, the tax court is the worst I've ever seen. They can fine you something like $25,000 per argument that they deem to be frivolous. So you could actually walk out of there with a $250,000 penalty, which people can say, well, but it's a fair system, Mark. You do get to appeal from the tax court, not if you don't put up a bond equal to the penalty. So they could already have been trying to get, let's say, $100,000 from you. Then they can hit you with a $200,000 penalty. Where the hell are you going to come up with $300,000? And if you don't pay that, you don't appeal. And good luck trying to get them to waive it. So it's just something I wanted to bring up when we do fight these things and we do go toe-to-toe with them. Going through the appeal process can be costly, and there's almost nothing we can do about that. Yes, you can get it deferred and you can get it waived, but most of us don't want to give up the financial information in order to do that. But it is possible to do that. So, and the big expense there is going to be the transcript. The transcript should be, in my experience, the way I do it, should be the biggest expense. And that's it with us. Most of the time, Bao, these trials don't take more than a few hours. It's not like you're going to have a 19-day trial and you're going to have a $15,000 transcript.
Yeah.
Which with voice recognition software, why would you need it anyway, right? You could just have it recorded, and as long as you're not having some douchebags in court talking over you. But anyway, all right. So I wanted to get that out. So if your back's up against the wall, not guilty, let's get the hell out of here. But I would still take the option before and test the waters and still hold the prosecution to their burden. I will plead guilty right now if the prosecution has evidence proving jurisdiction that the code applies because I'm in Texas. I will plead guilty right now.
Gotcha. I've actually tried to speak with the prosecutor a couple of times at the prosecutor's office, and they've refused to speak with me. Should I bring that up at all, or just don't even consider? Don't even bring anything new in. Well,
you when you spoke to him, you still had the public defender helping you, right?
Allegedly. It's weird because I've been able to submit my own motions. On some of their systems, they're saying I'm pro se, or gosh, what's that word? Like I don't have an attorney, but on a couple, like when I went to try to get the discovery package, they're saying, well, we released it to the attorney. And then when I went and tried to talk to go ahead.
But that's their reason. The prosecutor legally cannot speak to you when you have an attorney. He could be disbarred. I mean, that's something that could actually happen to him. He could lose his. I know there's no such thing as a license to practice law. I get it. But he could be disbarred. So the prosecutor's not going to risk disbarment as long as that at least looks like that public defender is assigned to the case. He's not going to risk his career by talking directly to and communicating directly with you. So that's his out. If he's standby counsel, he's got no excuse. But I don't, from what I already know about this, it doesn't look that way. And so that's his out. So if this public defender isn't going to be standby and he can't be fired, you got some real problems on your hands. So, but the judge is letting you. But didn't you say the judge is letting you file your own paperwork?
Well, not the judge, the clerks. Like when I went to file all these motions I've been filing, the clerks has been taking them, filing them, and in the clerks' system, they have me as pro se.
Okay.
Or no attorney.
Well, as long as you're down as pro se, then you should be able to take that court record to the prosecutor. But he may argue, look, I don't have anything about the public defender withdrawing. This looks like it may be just a clerical error. There is something going on there. I mean, but as long as they've been accepting the paperwork, because if you were actually represented by the public defender, then the clerks wouldn't have accepted the paperwork. Then again, the clerks may just be making a mistake. So until you get something from the judge that public defender is at least standby or has been thrown out, the prosecution has an excuse not to communicate with you at all. So,
well, here's the thing: on the file they have on me, on the very front cover page, Mark, the very last thing on the log is no attorney.
Wow, that's. Well, that's something. Then you're gonna then with that have that in hand when you raise this issue tomorrow, that the prosecution has no legal grounds to not communicate directly with me, because it says right here no attorney. So this, I believe, and you can argue that this is a Brady violation, that they're refusing to comply with Brady by giving me the information, exculpatory information, and regarding their witnesses.
Got it. Another thing I was considering was, do you think it would be beneficial to me to make one more effort to talk to the prosecutor tomorrow morning prior to my time that I'm supposed to appear?
Yeah, you could use some of his statements against him. So let him know, let him see that the court record that says no attorney. Now, sir, that you don't have any grounds whatsoever not to speak to me. I want to resolve this, and I do intend on pleading guilty here today. And use that as your way in.
Got it.
And if he doesn't want to, you can use that with the judge when you start arguing a Brady violation and prosecutorial misconduct. I gave him another opportunity. I'm willing to plead guilty today. He's not willing to exercise any good faith whatsoever. Because the only good faith excuse he had is gone when you have a court record that says no attorney.
Gotcha. One more thing I wanted to ask you, Mark, was one of the scenarios that we were kind of brainstorming was them using that public defender to kind of bind me by not letting me talk. And then, letting the public defender talk and bind me to something. How would you go about handling something like that?
Well, you would say, and I would say, it was ineffective counsel. He did things that he did not run past me. He allowed the judge to make a unilateral decision that I was crazy and didn't even object. He didn't even know the grounds, and not even knowing the grounds, he didn't object. I got to tell you. That is bad. That is some serious ineffective counsel there. Your own client is being declared crazy, and you don't know what the hell the judge is basing it on. You don't even come in with a limp dick kind of objection. Objection? What's the grounds for thinking my client? Nothing. So, yeah, I want an attorney or someone who thinks that lawyers and the government are good, honest people for the most part, and good faith and an ethical organization. Go ahead and make an argument for standing mute when your own client is being forced into a psych evaluation and you don't even know the grounds. Go ahead and make an argument, somebody. I'd love to hear that. Ugh. So yes, it's ineffective counsel. And those are the examples that I would give. You had no idea and you did not agree to what he did. He did not disclose to you. He never explained to you the legal implications. That's very important for you to mention. His job is not to just go on autopilot. When he's making decisions that for your defense, he's supposed to run it by you so that you know what the legal implication of that is. So just like if you were going to plead guilty with a lawyer, the judge is going to interview you to make sure that your lawyer has explained certain things to you. So here he did not do that. So make sure it's ineffective counsel. He didn't explain things to me, didn't give me the legal implications, and he stood mute when I had a judge, deciding on her own arbitrarily that I was crazy. He just stood there. This guy's not looking. He's not defending me. So,
got it.
All right, so I got to move on. I apologize, but we're actually nobody was calling the first part of the show, but I think we got enough there, and just get I'm sure you'll do some more role playing tonight after the show.
Oh yeah, I got it. Cool. Thanks, Mark. Thanks for taking my call.
Yeah, hey, no problem, and good luck. Let us know what happened. All right.
You'll hear from me. You'll hear from me. Someone will check in.
Good deal. All right, we'll hear from Bao tomorrow. Get as many calls in as we can. Holy crap! I just looked at the time. Let's see. We have area code 571. You're live on the No State Project. What's your name? Where you calling from?
My name is JJ. I'm calling from Virginia.
JJ in Virginia. What do you have for us today?
So I got caught up with some tickets that I wound up standing in front of a judge, and I caught him on conflict of interest, and then he held me in contempt. And so I wound up taking some shitty plea for the other charges, but I'm still battling the contempt, and it's in the higher courts. It's in the circuit court instead of general district. And I'm just trying to find out. I bought the.
How did you catch him on a conflict of interest that then led to him being triggered to hold you in contempt? So let's take one thing at a time. How did you get him in a conflict of interest?
Okay, I went with a different approach. I went with the whole birth certificate and straw man approach, and basically pointing out that he was a trustee, and he what happened is he told me that I was confused about it, and I asked him who did he work for, and he said he works for Commonwealth of Virginia. And I said, well, how can this possibly be a fair trial if you work for the Commonwealth and the prosecutor works for the Commonwealth? And then he tried to explain that he gets that there were two different departments. He gets paid from a certain part of the Commonwealth, and the prosecutor is separate. And so I kind of just stuck to that point, and then they started surrounding me with a bunch of officers or sheriffs, and it kind of threw me off. And so he told me to come up. I wouldn't cross into the bar or to the defending table, and he tried to force me to move up there, and I told him, I'm fine where I'm at. I talked to him for 15 minutes, almost 20 minutes, and when I caught him on a conflict of interest, that's when he turned and said, well, if you don't come up, I'm going to hold you in contempt. And so they went to lock me up and gave me 10 days, but I told the sheriffs in the back that it's kidnapping. And then magically they did an appeal on their behalf, and I was out of jail in like 35, 40 minutes.
Wow, that's impressive that they had, okay, so really bad going in doing birth certificate stuff. So thank goodness at least they didn't order a psych evaluation. You did okay. You did all right with that, and you asked just the question. I guess I would have put it, well, so you're representing the same entity, or that you're representing the plaintiff the same as the prosecution's representing the plaintiff. So it may not have changed anything, But that's why you want to stick to just asking the questions, and they probably so we can hopefully avoid the contempt charge. Did he? Well, the crossing the bar. The thing is, they believe they have jurisdiction whether you're in front of the bar or outside the bar. But that's the whole. It's not really an issue. Does an appearance? Does that waive personal jurisdiction? Yeah. Yes, it does. But you're not appearing. You're participating, and that's why in my paperwork, I said, look, I'm participating on the threat, duress, and coercion. I am not appearing. Appearing, for those who are new, appearing is a technical word of art. It does not just mean you're physically in the court. It means you're submitting to the jurisdiction of the court, which is why you have what's called a special appearance, where you're challenging jurisdiction and sufficiency of the complaint, and you're not appearing. They don't recognize a special appearance, at least in the United States, in criminal proceedings. They don't. So we're still going to challenge jurisdiction, but we're not going to appear. We make it very clear, I'm not appearing. So now you're dealing with this contempt charge. Yes, I recognized who you are from the Skype. Why is the contempt charge in a higher court than the trial court?
Because when I told them it was kidnapping, they, I guess, huddled up and came up with a way to get me out of there, because I guess they might have been scared, because since I didn't put in no plea. And so they did the appeal work on my behalf. I didn't do the paperwork. They said, well, I need you to sign this, which I should never have signed it. And I signed it, and then it went to the circuit court. And then I'm dealing with circuit court, and each time I go in there, they're just being very aggressive, and they tried to lock me up last time because I was trying to explain something to them, and it was like, well, we need you to, they wanted me to have a court-appointed lawyer, and I didn't want one, but they threw me in jail, and it kind of put me in a position where I wound up taking a court-appointed lawyer.
Wait, did they say to you, you either get this lawyer or you're going to stay in jail pending a trial? Did they say something like that to you?
Yeah, close to that. Yeah, the first time I was in there, they was like, well, if you don't get a lawyer, then you're going to jail. That's what they told me. And then I was going to look for a private lawyer at first, but I've been doing a lot of research for a long time, and it's just each time I come in there, it's like the intimidation, and they surround me every time I'm in there.
Sure.
And so they gave me a court-appointed lawyer. I talked to the court-appointed lawyer last week because I was going to have the court-appointed. I was going to try to have them challenge jurisdiction, even though I know they're not going to do that. And when I went to talk to her, she said she couldn't represent me because she was in general district court when I was facing the other charges when the first judge gave me the contempt. So she said she was a witness, so she couldn't represent me. So she put a motion in to withdraw herself from the case. And so on Friday morning, I go in there, and they're either going to try to force me again or try to assign me another court-appointed lawyer. But at this point, I really don't want a court-appointed lawyer.
I would get a challenge into I know it's a broken record. I would get my challenge into jurisdiction immediately, and I would start arguing that and trying my best to hold the prosecution to their burden of proof. Because you would really need a sympathetic judge if you argue the merits that just because you wouldn't come in front of the bar, I mean, they're probably going to say, yeah, that's contemptible. I mean, the judge ordered you so many times and you didn't do it. Does it bring down the dignity of the court? Well, it's a direct confrontation to his courtroom authority. So I don't know if you're going to get a sympathetic judge that may say it is contemptible, but maybe 2 days in jail. So I don't know, or maybe they'll suspend a sentence. So I would stick to the program and be challenging jurisdiction and give a Brady request, of course, because the prosecution's on the hook too. They have to have witnesses, and the witnesses have to have personal first-hand knowledge. And here, they have to show that the judge had personal jurisdiction. And I don't buy this garbage where you were there. He forced you to be there. You weren't there of your own free will, were you?
No, yeah, they definitely forced me.
Yeah, so this idea that, well, the rules apply because you were there, and I was forced to be there. Where was the evidence proving that he had any of the jurisdiction to get me into the court in the first place for his rules to allegedly apply? So that's why you got to always hit the foundation. He had to have had jurisdiction just to have you in the building against your will to begin with. So that's why I still just hit the foundation. So I motion to dismiss for lack of evidence proving jurisdiction. To me, and I think that anybody with two brain cells and understands the principles of logic to any degree would say, you can't turn around and force somebody onto your property and then say that they're subject to your rules. That's nonsense. That is fantasy land. That's the crap that you get if you engage in a discussion on Facebook. Oh, you were there. I was forced. I was under threat, duress, and coercion to be there. And I don't want to hear any of these ANCAPs saying his property or that the property rights are king. His property, he could do whatever he wants. Aber fungul. That's nonsense. You were forced to be there, and it's obviously under threat, duress, and coercion. Because if you hadn't shown up, he would have issued a warrant for your arrest. So that's how I would take care of that. But I am really, really low on time, and I hate to do that to you, but I'm going to try. I recognize a number here, and I'm going to try to get in a few more callers. But that's the best I can really do for you today, and I would suggest getting into the No State Project Skype chat so that you can do some role-playing to prepare when you do go in.
Okay, one quick question before you go. I got your motion and discovery, and I just want to know on there it says Virginia, and I'm dealing with Commonwealth. Do I put Commonwealth in there, or do I just put it as Virginia?
You can put it in as Commonwealth, or you can put it in as state. State and Commonwealth are interchangeable in the United States. It's okay. As far as I've seen, it's most seem to agree that it's interchangeable on the international level too. It's a state. Look at a passport. It won't, it'll say State of Israel, or State of So they're interchangeable. So you can use Commonwealth or you can use state.
Okay.
And if you have any other questions on that, just Skype me or email me.
All right, no problem. Thank you.
Hey, good luck and let us know what happens. All right.
I definitely will.
All right, appreciate it. Good luck to JJ in Virginia, and we'll go to. I'm going to run out of time. I can't really go over today, but I'm going to do my best. We have area code 706. You're live on the No State Pro. You're live on the No State Project. What's your name? Where are you calling from?
Hey, I'm calling from Georgia. This is Grace.
Grace from Georgia.
No, not Grace. Gray, like the color.
Oh, gosh. Gray. Okay.
Gray. Grey. Yeah, we briefly spoke on Facebook a couple times. But yeah, I was wanting to call in, just address just really my main concern with what you teach, And I feel like your intentions are good, but there's just a couple things. So your main premise is prove that the law applies. Is that correct? Hello?
Well, that's a tactic that we use. My main premise is that there is no government, that they're just a group of men and women forcing us to pay them, that they're a criminal organization, and through that.
Right, but do you not have people raise the issue or question of, prove that the law applies, prove that the Constitution applies, and whatnot? I mean, is that not?
Well, to be more accurate, you're pretty close, but I don't think I'm trying to split hairs here. What we're doing is asking and challenging the claim of the police officer or the IRS. We're challenging a bureaucrat's claim that just because we're physically in Arizona, their laws apply. That's what we're actually doing.
Okay, now does that apply? So does your premise, are you applying that? Is it consistent, or is it just some laws, or is it all laws? I'm wanting to.
We're striking the foundation. This is why we talk about the Constitution and Code. We're talking about all political laws, all of them.
Okay, so all of them. All right, so I'm glad we got that. Pretty much we can agree on that as far as as far as your premise goes. But so what about somebody's, what about due process, or any of the other fundamental rights that are enumerated in the Constitution? Do those apply? Do you teach that those apply to people and that they should stake claim to those rights being reinforced and enumerated?
No, what I suggest doing is that I would never invoke my Fifth Amendment right. What I bring out is that the judge, who's allegedly, and provably doesn't, but it's supposedly, this is when we're in the process, that they supposedly have an obligation to provide due process. So we say that they're violating their code, but I'm not saying that the judge has an obligation to do that, but I'm taking advantage of the public relations and that their actions are not consistent with their own rules. So to show that it's unfair.
Okay. So not with regard to your own rights that are upheld and affirmed, by way of the law. So pretty much what I'm saying, it just seems to me like pretty much you're telling people to say the law doesn't apply, while pretty much not having, claiming that the law does apply to yourself with regards to rights. Is that not correct? Or,
no.
Or that it shouldn't apply?
No, I have gone and said many times I don't have a Second Amendment right any more than you or anyone else does. That is called, I have been very clear that all of it is public relations. It is to divert, this is going back 20 years, to Adventures in Legal Land in 2003. It is all done to divert your attention away from the fact that they are just men and women like us who are forcing perfect strangers to give them money. And all that stuff about rights and protection is just to blind you from the fact that they are a criminal organization. That the only difference really between them is them and the mafia and organized crime, as we know it, is that they have superior public relations in that they have convinced everybody that, unlike the mafia, they have a moral right to force strangers to give them money. Now, you can claim, but they do XYZ with the money. So does the Yakuza. The Yakuza is
right.
Okay, so...
But what I'm asking, though, is do you reject that the mechanism of which rights are not only recognized but protected and upheld is by way of the law? I just don't see the logic, I just don't see the logic between, on one hand, claiming that the law doesn't apply or rejecting or objecting that the law applies, while on the other hand, pretty much that just insinuates that applies to rights, too.
Well, because I believe that you have life, liberty, and property, and I can prove that, right now.
But how is that protected if not for the law? Just because you say so?
No, because one, if again, it comes down to public relations. The fact is,
public.
Okay, yeah, I've been very clear about that. Now they have to maintain some of the facade that they're there to protect you. They have to, because if they dropped all pretense that they were there to protect you, people might actually do something. So that's why you have police that it looks like they're patrolling to protect you when they're actually patrolling just to collect money. That's why police, for example, when there's an actual situation where children are being murdered, they stay outside. But if there was somebody in there, if there was a report that there were kids in there smoking pot, they would be going in there with guns blazing. Okay, so...
Right, but that still doesn't address that. On one hand, do you advocate for people to, point out where the law recognizes their protected rights? Do you or do you not, suggest that?
Only in so much as we can point out that their actions are not consistent with their own rules. It's just to show that they are criminals. It's to show that they are not actually there protecting you.
Right, but that's still with respect to the person, is it not? And so the only way that would need to be addressed is because the law applies to that person and protecting their rights. So what if somebody kidnapped your child and then your child was found, all right, and then you're pursuing either either criminal charges are being pursued against them or civil. What would be your response if the person who did it said, "Prove that the law applies to me"? What would be your response to that?
Well, one, I wouldn't like. It's to make it such a personal thing. I think is kind of taking a wrong turn.
Not your child. Let's just say someone else's child.
Look. I think it's terrible, and I think that the parents, and I know for myself, I would not be pursuing justice through the courts. I would be pursuing a parent's justice. Okay, but the bottom line here is no amount of. Let me finish. But let me explain. I want to answer you, and I'm going to go over the time so I can address these issues with you. No amount of tragedy that happens to my family, to my children, is going to be evidence making a criminal organization a legitimate one. So I'll use the Yakuza as an example. If the Yakuza goes and gets somebody's child back that was kidnapped, is that going to make the Yakuza any less? Does that mean that the Yakuza is now not a criminal organization? Does that negate the fact that they're a criminal organization?
Well, no, but we're not talking about legitimacy. We're talking about if somebody perpetrates a crime against you or your children, what would be your response if your method that you teach was used in a defense against you? What would be your response for someone to say, "Hey, prove that the law applies"? You can't prove that it applies. Well, the court doesn't have jurisdiction, and therefore nothing can be done.
Oh, something can be done. Something can damn well be done.
I'm talking about strictly within the context of the court system. Is that not what your show is about? Is addressing things within the court system?
It's part of the show. It's
strategies.
It's a big part of the show. Yes, the goal of the show is to empower people to be able to challenge these bureaucrats and to be able to get to a voluntary society. There is a big emphasis on courts because that's where most people are challenging them. Because most people, unfortunately, are not taking the initiative and challenging them outside of court, which is something that I lament all the time. But if the answer you want is what is my feeling if somebody was to go ahead and do that in a murder, I think that sucks. I think that's terrible.
But what would be your response? What would be your response in that scenario if you were in the courtroom and you were facing this person who had perpetrated a heinous crime against you or your children? What would be your response when they say, "Prove that the law applies to me"? I say that y'all don't have any jurisdiction. What's going to be your response? I'm
not going to like it. I'm not going to like it at all. Are you going
to acquiesce to their argument?
You got to let me finish.
Acquiesce to there being no jurisdiction?
Of course, no. I still would not concede that there was jurisdiction. No, there's still no evidence of jurisdiction.
Okay, so you would still say that the law doesn't apply to somebody who, steals, rapes, murders.
Well, first you got to remember that in a general sense, I don't advocate the harming others. I think I always say that the principle of do no harm applies to all of us. So if somebody in a murder trial try to pull that, no, I would not want to see that. No, I don't want to see something like that. I want to see that everyone who commits a crime gets justice. But that doesn't mean that I want to see that through the court system. When you've got the goods on somebody. So bottom line,
if you out with the bathwater here.
No, if you want me to, and I think I've already said it, I think it would suck. And it's no different here, okay, than if you were to be able to speak to the Wright brothers and say, how would you feel knowing that what you created is being used to kill innocent people? Of course they're not going to like it. But there are going to be people who do horrible, nefarious things that are going to use a good principle and use it to try to get away with what they got away with. But that is in no way... I think so you can go back on Facebook or your friends who love to slam me on Facebook because you're a lot more respectful here than you are on Facebook. I'll tell you that right now.
I've been nice. I've been nice during our encounters on Facebook.
You've been nicer. You've been nicer, but you have not been Okay, given what
disagree,
you said
but
to
I
me
think-
wait, let me finish. Given what you've done on Facebook, you're not somebody I would generally want to speak to. But you still, I
What
would
I've
rather
done on
speak to you.
Facebook.
I would rather speak to you than the guy who started all this. He is just wow, and the fact that you support this guy is anyway. But yes, I don't think that you can turn around.
I support the premise that I support that his issue and actually our issue that pretty much you're inadvertently stating that the law either doesn't or shouldn't apply to rapists, thieves, and murderers.
Political laws, no, but
when
obviously the moral code does, and they shouldn't get away with it. My position is that nobody. See, right now you have rape, killings, robbery. That there is a small group of people that they've convinced the world that they have a moral right to do that. I don't think that washes any more than any other person. I don't want anyone to get away with it. But I certainly don't believe it's consistent to say that,
So the system that you disagree with is that it's legally sanctioned rape, murder, and killing, and your answer for it is to sanction rape, murder, and killing within the general population.
I didn't say that. Now you're making no. Now you see. This is why I knew you try to twist it, and that's I've admitted it twice.
I'm not twisting it.
No, you are. I'm not. I am not giving a sanction. What part of do no harm applies to everyone? Are you not?
Did you not just say that?
You gotta have to let me speak. I did not give any sanction or say it's okay for people to kill. I said that it applies to everybody. Just because I'm saying the political laws don't apply to them or anyone else does not mean I'm okay and sanctioning that they go out and actually harm people where my basic moral principle is do no harm. So that's how you twisted it. I am not saying it's okay for people to kill, because that's the same knee-jerk type of reaction when I say that the laws don't apply and someone says, so you think it's okay to murder? No, of course not.
Well, I didn't say you said it was okay to murder. I asked about whether you think that the law applies to them or should be applied to them, or that there is evidence that the law applies to them within a court setting.
No.
And you said no.
No. The laws don't apply regardless of the actions of a few people, like, killing and or hurting other people. And I've been very clear on that, in whether it's a criminal or civil context.
Okay, but you're still saying that a hypothetical murderer or, kidnapper or whatever, should be able to use your defense. Yeah, so your response to someone like that in the court setting would be, well, I guess he's right. He asked the magic question, show evidence that the law applies. Well, I guess we're done here. It just, like I said, I really don't like generalizations, and it seems like your premise is a gross overgeneralization.
Okay, so let me ask you. Somebody hurt, just a random guy kills somebody, and he does it in Georgia. Okay? Does that prove that the Constitution applies to everybody and that there are citizens and that there's a state? Does that prove that there are citizens in a state?
Okay, so if somebody hurt somebody in the state of Georgia, does that prove that the Constitution and laws apply to the citizens of the state?
No. Well, let me see if I can make this clearer. Because for the laws to apply, you agree there has to be citizens that comprise a state and therefore a government.
I say that the laws apply via jurisdictional elements that's named within the statute. But what you're saying is that, that doesn't count as evidence, is the statute in itself.
Well, how is that evidence the Constitution applies? See, because for the laws to apply, there has to be a state, right?
For the laws to apply, there has to be there just has to be people.
So there doesn't have to be citizens in a state.
But there has to be an agreement amongst a group of people, and in this case, it's a group of people acting collectively.
There has to be an agreement, and they're acting collectively.
Right.
And you have,
Which is,
and given the fact that everybody has to pay or they go to jail, okay, given that fact, given that it's compulsory, you pay and you do as you're told and you pay or you go to jail. Given that it's compulsory, where is your evidence that there's an agreement that people are acting collectively?
the Constitution. The Constitution is, I mean, you got the delegates that signed it at the Constitutional Convention.
You do know no one signed as a signatory, right? They all signed as witnesses.
No, they signed as in a representative capacity from each state.
They signed as They signed as witnesses. Are witnesses parties to the agreement?
It was in the capacity. Where are you getting that they signed as witnesses? They signed in a representative capacity on behalf of the 13 states.
It's in the document, in witness thereof, we append our signatures. Now I ask you, are
witness thereof.
Are witnesses parties to a contract?
They witnessed it, and they witnessed this being done, and they were all witnesses of what was going on and the idea behind the Constitutional Convention, and they acted as delegates on behalf of the states.
Sure, and even those delegates that didn't, and you even had guys that were there that weren't even sent as delegates that did it, and then you had the fact that the Articles of Confederation required a unanimous. Let me finish. And then you had the Articles of Confederation required a unanimous vote to get out, and yet there wasn't one. There was but to get back, how does the Constitution show that there's an agreement when everybody was forced? Everyone is forced to support and pay? How is there agreement when everyone is forced? See, that's the sticking point.
The people entered into that agreement upon their own volition.
What people?
The people of the 13 colonies.
Okay, they
entered into that agreement upon. I mean, it was a mutual meeting of the minds.
So, but you're talking about the people. When were the people of the states given a choice on whether there was a government or not?
By voting.
No, there was already a government.
I mean,
Gray, there was already a government. Nobody voted. If you have, and I'm going to have to, I've gone way over my time. If you have evidence of American governments being instituted by vote, where they're voting whether they're going to have a government or not, you're going to have to produce that because
the Constitution was, so the Articles of Confederation, that served as a unifying document for a national government. So they already had state governments of their own.
I get that, but when did the people of let's say like New York or Massachusetts Bay, when were they given a choice as to whether there was going to be a government or not? Because from my understanding of history and what I've seen from source documents is, like in Massachusetts, after they got rid of the British authority, except for Boston, there was no government period for about 9 months. And then what they did was they just picked up and started using the same taxing districts, and they imposed their own government. And no one had an actual choice. It was still pay or go to jail. In fact, even when they started in 1775, they were known for taking entire plantations because people may not have supported. Look what they did to the Quakers, for heaven's sakes. They were killing them because they wouldn't support the war. So I have to go, but you're welcome to call again.
But there's always going to be people who don't. We're talking about in a collective sense right here. We're talking about the majority. Of course, there's going to be some groups of people that may or may not have liked the idea of a centralized national government. But the fact is that the majority of states, they elected and sent delegates to act on their behalf to sign the Constitution.
The facts but Gray, the facts are against you. No one at the local, county, or state level had a choice on whether there was a government or not. And then those same people...
They did have a choice.
No, okay, then you're going to have to show me where they had a choice on whether there was...
The delegates signed. They voted the delegates to go act on their behalf at the Constitutional Convention.
But you're going years later. In 1775, when all those... And there was 12 constitutions in 1775, not 13. Okay.
Why does it matter? Why does it matter beforehand?
Because we're talking
about the Constitution and what's actually enforced today.
But you have to go back to the beginning and see if there were 12 legitimate organizations to then send legitimate delegates to have.
There was a group. Okay. There was the colonies, And then they got together and decided we need a national government. And then they put together the Articles of Confederation. That wasn't working out too well. So then they implemented the Constitution. It's very simple. And they sent delegates to sign.
It's really not. And maybe go back and look at this and look at history again. And next time you call, you show me some historical evidence that would show that in 1775, when they created the state governments, okay, that the people had a choice. Okay, that it wasn't a matter of pay or go to prison.
Okay, all right. So the people had a choice as to whether or not to ratify and adopt the Constitution. Is that what you're saying?
No, I'm talking about 1775. I couldn't care less at this point. 1789 is completely irrelevant at this point. We're talking about...
Well, we're not just talking about the Constitution. You were saying about the Constitution applying, and then now you're talking about something else. I mean,
no.
So 1 minute we were talking about the Constitution, and the next minute you're talking about 1775 before the Constitution. I mean, you know?
It's obvious you're lacking an understanding of the historical basis for the Constitution, and that's fine. It's not.
I seriously doubt that.
Well, okay. well, let's do this. The next time you call, have historical, evidence, documents to prove that what we know...
That the Constitution was ratified and signed by the majority of the states.
I didn't ask...
No,
I'm not asking...
And further was adopted into their...
Okay, I've got to mute you because you're talking over me. What I'm asking you for is something very straightforward. We have to go back to the beginning to see if it was legitimate, or if there were legitimate organizations that then created the Constitution. That's what we're trying to do. So I'm going to have to let you go, and I appreciate the call.
So
wait.
If it's like a group of people, did they or did they not enter into this agreement? I mean, were they or were they not forced? I mean, it's very clear cut. But regardless, I'm just glad we got that. I'll let you go, but I'm glad we got that cleared, that you don't think that the law applies to rapists, murderers, and thieves. That was the main premise I was wanting to address.
Our moral principles do, and they are moral principles that they apply to everybody. However, political laws, there's no evidence that they apply to anybody, even the worst of society. But that doesn't mean, and we want to get to a voluntary society so that we can actually hold them accountable through a system that is not criminal in nature, that we want the means to be consistent with the end.
In a voluntary society, the law doesn't get applied to anybody?
Moral. We're talking about different. The moral code that we understand by the time we're 5 years old, that not to do no harm, and that we're not, and in a voluntary society, that it's not that a small group of people have the moral right to do immoral things, to do things that you and I can't do, which is why I asked him the question. If I was to do things like you guys, the government, and I forced perfect strangers to give me money, would you consider me a criminal? And hell yes! So what we're saying
How is the law applied in a voluntary society?
I'm really sorry. I'm not dodging the question here. I've had you on for a half hour. This is something we're going to have to address on another show because I'm way over time here. Okay.
Can we be clear? What time is your show? Because I'm on Eastern time and I got times confused, and I thought you were 7 o'clock my time.
4 to 7 on Saturdays, Eastern time.
4 to 7 on Saturday. Oh, okay. So you're on Eastern time too. All right. 4 to 7 on Saturdays.
And the other times, for like today, all the times and call-in numbers, they're all on markstevens.net.
Okay. All right, great.
Appreciate the call.
All right, well, it was nice. It was nice chatting with you, Mark. I appreciate your time.
I appreciate you calling in, and call in on a Saturday show.
Okay. Well, you have a good night, okay?
Thanks, you too. Appreciate it. My name's Marc Stevens.
All right.
We've gone way over. I do appreciate the call. I'm sorry for the calls I could not get to. I'm way over time, almost 50% over. And we'll get to more, everyone that we missed on Saturday. If it's court stuff that you want and you still need to contact me, you can always email me off the website, markstevens@mail.com, and Skype is frankrizzo3. So no one's going to be left hanging, and do suggest that everyone get into the No State Project Skype chat. This has been episode 54 of the No State Project, and using logic, if we're going to examine something that organizations did in 1787 to 1789, mind, we have to examine what the creation and how those organizations came into play. To ignore how they came into play is not logical. It's not rational. So we have to first determine that there were 13 legitimate organizations that then created an agreement. And the fact is that none of them had a choice. None of them had a choice. They went and they replaced the old taxing districts from the colonies, and they started, and that's historically accurate. That's what they did. Nobody had a choice on whether it was a government or not. If you were an anarchist or you were a pacifist like the Quakers, you didn't want anything to do with the government. They just took your stuff. That's criminal. And that's not even talking about how the war for independence was really a war of expansion, that they were fighting on two fronts. Destroying Indian villages, anyway, I don't have the time, but we have to look at the creation of the so-called states to then be able to to determine that what they did later was valid. So we can't ignore the beginning. We have to look at the beginning. And they had constitutions too. Where's the evidence that they apply to anybody? Nobody got to vote on those. See, if you have no choice in whether you have a government or not, it doesn't matter if you get to vote for a delegate. A man is no less a slave because he gets to pick a new master every 4 years. Lysander Spooner, I'm paraphrasing there. But anyway, we'll get to whoever we missed today, we will get to you on Saturday. We will be live. This has been episode 54 of the No State Project, here from the fortified compound in Mesa, Arizona. We'll get this posted as soon as possible at markstevens.net. But till next time, salud.